Hey there, welcome back. Thanks for joining us for this awesome master class. I'm Nicole Holland, and today I am pleased to introduce you to my friend and attorney, Bobby Klinck. So today we're going to be talking about legal made simple for online entrepreneurs. Let me tell you a little bit about Bobby. He is an intellectual property attorney, but he's not your typical lawyer. Sure, he went to Harvard Law School and worked at some of the most prestigious firms in the country, but if you look at his big whiteboard in his office, you're not going to see much about the law. His whiteboard is filled with tasks related to platform building, inbound marketing, and sales funnels. He is a full-fledged online entrepreneur whose area of expertise is the law, and he helps other online entrepreneurs safeguard their online business. I know this is something that is hugely important to my audience, and so it's a great pleasure and honor to have him join us today. Hey, Bobby.
Hey, Nicole, it's great to be here. I'm excited to talk to your audience and your crowd and help them through this kind of complicated or sometimes complicated set of issues that really doesn't have to be that complicated.
Fabulous. So let's talk about your process. We have a number of things to cover today. So where do you want to start at?
Well, I mean, I don't know if you want to start with kind of just an overview of the kind of a quick point. Hey, here are the things we need to talk about, and then we can talk about them in more depth. Might be a great way to do it.
Yeah, I think that's great. So what are the points that we're going to cover?
Okay, so I'm going to kind of start at the beginning. It's not necessarily in chronological order, but it kind of is with where you start your business. So issue number one is you need to create some kind of corporate entity for your business, and we'll talk about what that is and why. Second, you need to make sure you can legally use your name that you pick. Third, you need to get in the practice of using written agreements. Any agreement in your business needs to be in writing, and we'll talk about that and kind of what's involved in that. The next piece is you need to start thinking about protecting your confidential information. Now, some of your crowd, Nicole, probably thinks about that and says, well, duh, but a lot of people don't. A lot of online entrepreneurs don't, for example. So that's something we need to think about. Then you need to think about what do you need to do to make sure your website is legally compliant, has all the right policies in place on that. And then the last piece I like to suggest, and a lot of people don't like this, is you got to get some legal basic training. And for most entrepreneurs, the most important piece is understanding intellectual property law, and people get it wrong all the time and get confused about things, which I get, because if you haven't been trained on it, you wouldn't, but it's really important to get that basic training. And what I like to say is, unless you're going to hire someone like me to be sitting there looking over your shoulder every minute of every day, we're not going to be with you. So you're going to have to make some decisions without us and at least spot some issues. So that's why you need to get that training. So those are the big points that we need to cover, I think.
Awesome. So let's get started with the corporate entity.
Okay. So the reason you need to do this is, and what I like to say is, if you are serious about your business, if it's more than a hobby, you've got to create some kind of corporate entity. And it's going to depend on where you are. So Nicole, you're in Canada, so you're going to have to do one thing. Here in the States, it's almost always going to be the right thing if you're just starting out or an entrepreneur to create an LLC, a limited liability company. The other state or the other countries don't have that. You would just create a limited company. Normally is the option, for example, in Canada, the UK, Australia, pretty much most of the English-speaking world besides the US, it would just be called a limited company. The reason why you do this fundamentally is to avoid personal liability for things. And it's not a silver bullet. So myself as a lawyer, for example, I have an LLC for my law firm, but even though I do, if I screw something up in my law practice, they can still sue me. I can't get out of that for what I did. But if I have someone working for me and they screw up, they can't sue me personally. If I have someone, an outside contractor working for me and they infringe someone's copyright, they can't sue me because I got the LLC. And so you have that kind of protection. If you don't take action, if you don't set anything up, anything that happens in your business, you're personally liable for. And that includes a lease, that includes a contract, that includes anything. And if you have a partnership and you're working with someone, you're also responsible for everything they do and anything they might screw up. And so if you just start thinking about it, I don't know about you, but I don't want something in my business to potentially take my house or take my car or sink my personal finances. Fundamentally, that's why you have to create a legal entity, to avoid that. Now, there can be some minor tax advantages for some forms, but that's not the reason to do it. That's kind of an added benefit, that might come into play depending on where you are, et cetera. But the fundamental reason is to avoid that kind of liability. And the example I use always is my law firm. It signs every lease I've ever done. So if things go belly up and I don't have any money, I can walk away. And my landlord can't sue Bobby Klinck. They can sue Klinck LLC. And again, if it went belly up, there's nothing there. And so it's not a problem. And that's why you want to do it. And it's generally a pretty simple process. I don't know everywhere in the world, but here in the States, normally you're going to file something online. It's going to be 10 questions or less. And unless you're in California, which is kind of the one outlier, it's going to be pretty cheap. In California, it's kind of expensive, but everywhere else, it's less than $500 to set it up. A lot of places, it's less than $200. And so it's just a no-brainer most places.
Awesome. All right. So, do you have, I know there's a lot of kind of sites and things that, quote, help you do that. Do you have any recommendations for that, or the way that people can go? I know you can't give legal advice on the show, but do you have any ideas that you can share of some of the options that people can go to set that up?
Yeah. So again, I can speak to the US. I know, for example, generally you shouldn't pay someone to do this for you. Maybe you can pay some automatic or online service, but you should not come hire me. If you don't have a company and you're going to say, okay, he said I should form a company, let me form an LLC. You should not come to me and hire me by the hour to do it, because it gets very expensive. I mean, lawyers are going to charge you thousands of dollars. Like I said, so here in DC, to actually form your company, you go online and you have to answer like 7 questions, and that's all you have to do. And it's pretty simple. So there's no reason to do that. Now, there's one step beyond that. You're going to need what's called an LLC operating agreement, which is something that think of that as kind of the agreement between you and the company, because once you set up a company, there's 2 entities legally. You and the company are separate. So you've got to have this agreement in place, and it talks about, how it's going to be managed and what's going to happen and things like that. Again, if you're a solo, just yourself, I mean, it's kind of funny. You say, I'm the manager, I'm the owner, I'm everything, but you put that in place. You can get that form a lot of places. I sell one, LegalZoom sells one. You can get those a lot of different places and do it yourself. There's no reason to pay a lawyer to do that, candidly, just because it's going to be pretty expensive. Now, if you're more complicated, if you're a tech company, if you think you're going to raise money, then there might be a reason to do it. But if you're just now hearing this and saying, okay, I'm going to form a company, you're probably not there yet. And so it's a pretty simple process. A site like LegalZoom, if you just want someone to do it all for you, I think you can go to LegalZoom and they'll actually do the filings for you as well. You'll pay an extra couple $100 to get that done. I don't know the exact price. I don't do that. I don't have that through my site because I'm like, I don't want to get in that business. But you could do that for an extra couple $100. So that's an option if you want to go that route. But like I said, it's not something that you need to hire anyone to do beyond getting that form. Now, while we're talking about this, though, I do want to address one issue that often comes up. A lot of people have heard something about, oh, I should form my company in Nevada, for example, because there's no state taxes there, or things like that. That's all bad advice. Where your company is formed does not affect your taxes. You're going to pay personal taxes wherever you are. So generally the advice and the recommendation is, especially when you're starting out, form it where you are. It makes it simpler. It makes it cheaper. It makes it easier in the long run. So just find some service to do it where you are, and you'll have no problem.
Thank you for that clarification. That's fantastic. All right. So how about names?
Yeah, so this is one where a lot of people make this mistake. And my favorite story on this, Nicole, so this is about trademark law. And under trademark law, that protects basically a name, a logo, a slogan, anything that kind of designates the person or the company behind a product or a service. So I like to use Nike as an example. The word Nike is a trademark name. The slogan "Just Do It" is a trademark slogan, and then the swoosh is a trademarked mark. And so all of those get protection. For you as a new entrepreneur, as an entrepreneur starting a business, your name is the most important piece here. And so you have to make sure that someone else doesn't have the rights to that name. And Nicole, this is the story that I like to tell people about this that always makes me laugh. When I was first starting to get into content marketing and inbound marketing and doing those things, some guy approached me. I don't even remember his name at this point. He was trying to sell me on, he was going to set up a podcast for me, run it all for me. All I had to do was show up and do the interviews. He was going to find my guests and everything. You'll laugh at this. I think they wanted to charge me like $8,000 a month or something to do it for me. But, I wasn't going to pay that, but he offered to have me on one of their shows that he had set up to kind of show me how the process would work. And I said, okay, sure, great. So they had me on a show, and they were like putting it on like Apple News is how, like the link they gave me. I was like, I don't even know how to do that. So I went on to iTunes and I searched the name of the show. And not one, not two, not three, but 4 different shows with the exact same name come up. You can't do that. The first person who does it has the right to use that name and could come back later and tell everybody else, stop using that name. And so you need to run what's called the trademark search to make sure that's not the case.
Can I just butt in here and say thank you for clarifying that? Because I know at least 5 companies that are using the same name. And so I thought, oh, well, maybe it's different by state. Like maybe it's just in your state that you can do that, or in a country. I know a friend of mine recently shared with me a frustration because he's had an online educational platform for a couple of years by one name, but he didn't have the domain, and somebody just decided to use, who already had the domain, who decided to start, using the exact same name. And these are people in different countries. So
well, and the countries can create a possibility. So here in the United States, we have what's called common law rights to trademarks. So you get protection automatically once you start using it, and you get protection. It's geographically limited, but for example, in the online space, it's not geographically limited to where I am. This in and of itself is kind of weird. It's like, well, I probably get protection where I've sold something. If I sold something to someone in Minnesota, even though I'm in DC, I probably have protection there. It's murky there about exactly where it is. But you get that protection automatically. You get more protection by filing to register your trademark at the national level. Some countries don't have common law protection. So some countries, it's literally the first person to file gets the protection. But again, what I like to tell people is here, in the United States, we're kind of one of the biggest markets. So you've got, even if you're in another country, if at some point in the future you might want to be in the United States, you got to make sure there's not someone already using it, because that could prevent you from using it. And again, it's not just geographically limited. There's also, people can use the same name in different areas of commerce. And again, it wouldn't make sense, but let's just say that someone wanted to use Your Online Genius for the name of a local coffee shop. Well, they could do that probably, because no one's going to think that that's the same company as my company, Your Online Genius. The standard in a trademark issue is there a likelihood of confusion? Well, going back to the example where I had the funny thing happen in the podcast world, well, they're all in the podcast world. So obviously there would be some confusion there. And when you look at that, it's pretty obvious. You can have some hard questions come up, but what I like to tell, entrepreneurs who are at this point of starting out, it's probably not worth it. If you do a search, and you do this by going to in the US, you go to the United States Patent and Trademark Office, you can see if anybody's registered the mark, but you also do a Google search, and you do a domain search, and you do a social media search. And what I tell people is, if there are some blemishes there and you haven't yet invested a lot of money in the name, just find a different name. Because otherwise you're going to have to come to someone like me, pay us, it's often going to be multiple thousands of dollars to get an opinion. And here's what our opinion is going to be. It's either going to be, we think you can use it, or we don't think you can use it. But then we're going to have this much language that says, we make no guarantees. We can't be sure. They may still sue you. So don't rely on this. And that's usually not a very good use of a few $1,000s. And so most times what I tell people is, if there's a potential problem, just find a different name. It's ironic. When I filled out kind of the form to help you with this interview, I was thinking I'm going to be launching some courses that I was going to call them Legal Made Simple for. And then I did a trademark search, and it turns out that Rocket Lawyer has a trademark for Legal Made Simple. I'm not going to use it, even though they're not offering courses as far as I can tell. I'm just like, it's not worth the risk. And so I'm picking a different name. And so that's the best practice, is just make sure that it's a good name. It's a clear name. Now, if you're using your personal name, generally not a problem, unless your name happens to, for example, be Nicole Kidman. Then you might have a problem, and Nicole Kidman might have a basis to say you can't use her name. But otherwise, you're going to be able to use your own name without any concern. But then you have to think about things like your tagline. Are there things like that you should think about protecting?
Excellent. I'm loving this. All right. So let's talk about agreements. So You're saying get them in writing.
Yeah. And this is one where what I like to say to people is, if an apple a day keeps the doctor away, an agreement a day keeps the lawyer away. And that should be your goal. You don't want me in your life because I'm a nice guy. We can have a beer and a conversation together. But if you have to hire me because there's a dispute, you did something wrong, and it's expensive. It's going to be painful. It's going to take you away from your business. And the best way to do that is with agreements. And the funny thing is, this is a mistake I made myself. So I started my own law firm because I was at this other law firm with these two guys. They had started it like a year and a half before I joined them. I joined them. We didn't have a written agreement about how ultimately I would kind of get equity in the firm. They treated me fairly, but then my wife gets pregnant, and I said, hey, we got to figure this out. And we couldn't work it out. And so I had to go and start my own law firm because I'd made this mistake. And I'll tell you, it's not just that it hurt me that way. It will often hurt you personally. To give you a sense, one of those guys, one of the partners in that law firm, had flown through Hurricane Sandy, literally got on the last flight from Florida to the Bahamas, flew through that tropical storm to get there for my wedding. I haven't talked to him now in over 4 years because we didn't get an agreement in writing. And so those are the kinds of things that will happen to you. And so every agreement, every relationship that's important to your business should be in writing. And you don't have to make it perfect. There's a lot of stuff I would want to include as a lawyer, a lot of legalese and things like that. But the important thing is set out the crucial terms. And the crucial terms are, I agree to do X, Y, and Z. You agree to pay me, X amount of money. And be very specific. The more specific, the better, because you don't want there to be a dispute down the line. And a lot of people don't like doing this because they're like, oh, my clients aren't going to want it. They're not going to like it. Explain to your clients it's going to actually protect both sides. And the example I can give you where it protected another side, I hired some people. So as we're recording this, it was about 9 or 10 months ago. So the end of 2017, I hired this guy who brought in a contractor, and they were going to help me with some marketing stuff at the time. And he put a whole list of things. There were like 32 things they were supposed to do in the first month. They didn't do it. And because they didn't do it, and the contractor kind of fell off the face of the earth, there was no question I was getting a refund. And there was no dispute. There was no ill will. And so now if I ever had a need for what this guy's actual specialty is, I might go back to it because, it worked out and there was no problem because we had a written agreement. But if it had said that they would provide me marketing services, well, they kind of did that. And so, you need to be specific in these things. And, like I said, there is a lot of legalese that I would put in there that if you hire a lawyer is going to put in there. And that's important too. And a lot of people say, oh, but I don't want it to sound so legal. And what I tell them is the reason why that language is there is because it's battle tested and it's kind of gone through disputes before, and we know it'll stand up. So don't fight your lawyer on legalese. Include that stuff if they tell you to. You can have the other stuff too, but include some of this stuff that will help to protect you.
Awesome. And I think you have forms that are sort of templated. I know I've seen that in other places. I oftentimes will have an agreement that I write out sometimes just out of my brain what I think is important, and then I send it off to a lawyer for review, and they send it back to me with telling me what to do.
Mm-hmm.
And then they'll check it again and make sure I did it okay. So is that something like, how do you recommend people go about writing their forms?
Well, so that depends on how much time you have versus the money. So you decide that yourself. But I'll tell you, even a lot of big name entrepreneurs I know who make a lot of revenue still buy a template, start from that, and then go have their attorney review it. I was talking to someone yesterday who she's maybe going to do a licensing deal. And I basically said, and she said, well, I found a template. So yeah, why don't you start from that, get it done like you think it's going to be done, and then send it to me. And then, we can do it. Again, I charge $500 an hour. Lawyers are expensive. You don't want to pay for our time creating stuff. And what I like to tell people is, especially like on one of these contracts, like, I could get on the phone with you for 30 minutes to an hour to talk about exactly what you want and what the terms are and what's the person's name that I should fill in on the other side. And then I can go back and I can do all that stuff, and I'm billing you the whole time. Or you could do all that basic legwork, send it to me, and then I could make sure all of the niceties are there. And yeah, I mean, I've got templates and those templates you could start with, and I mean, you get it, and it's going to have all the legalese you need and all of these, things in there that talk about, there's things called an entire agreement clause that basically says, hey, this is the whole agreement. There's nothing else, and stuff like that. But those are the kind of niceties you'd miss. But at the end of the day, yeah, my advice generally is try to do as much as you can yourself. And then again, and if you can't afford a lawyer to actually look at it, find a good form tailored to your need. Make sure it's tailored to whatever you do. And the example I like to use is, and this isn't exactly an agreement, but we'll talk about the website policies in a little bit. Like, if you're an e-commerce provider, you need one kind of website policy. If you're a coach, you need a different kind of policy, right? Because you're doing very different things, have very different concerns. So you got to make sure that the template you find is built for your business. So for example, if someone is an e-commerce provider and they come to me and said, hey, I'm probably not your guy, because that's not really what I spend my time doing. I spend my time with coaches, with course creators, with those folks. And so what I'll say is, hey, maybe you could start with this, but you need to go find some other templates and some other information to help to actually meet your particular needs.
Brilliant. So can we just jump to that now? Can we continue talking about making your website legally compliant?
Yep, sure. That's perfect. So there's a few things you need for your website. One of them is an absolute must. There's no ifs, ands, or buts about it. That's a privacy policy. You are legally required to tell people certain things if you're collecting information from them. And I'm assuming anyone listening to this show is collecting information somewhere on their website. It would be a very strange website that's not collecting something somewhere. So you've got to have a privacy policy. That's basically to say, hey, here's what we collect. Here's why we collect it. Here's what we're going to use it for. Here's kind of categories of people we'll share it with. Here's what we're not going to do with it. And then your listeners may or may not have heard of this thing called the GDPR, which was a mess that came out and actually went into effect in May of 2018. It's a European Union law, but it affects anybody who is collecting information from people in the European Union. So you have to disclose some other things, basically give them some rights that they have, tell folks about those in your privacy policy. That is mandatory. Here in the United States, there's been a California law that mandates it for 15 years now, I think. And then the European law pretty much mandates it. So that is a must. Then there are two other legal policies which you should have. One is the terms of use, and maybe you've heard terms of service is what some people will call it. This is the basic roadmap or the basic rules of the road for your website. It says things like, you'll tell people what they're allowed to do, what they're not allowed to do, what they're allowed, how they're allowed to use the information, how they're not allowed to use the information on your website. if you sell products, you're going to have a kind of a basic refund policy in your terms of use. For example, if you have like ebooks and things like that, where you're not going to make someone sign a separate contract to get that, you'll put all of that into your terms of use. And there's some other random stuff that goes in there. Legalese. I mean, it's a pretty long document. I think my template is like 13 or 14 pages in Word, but a lot of it you don't have to change. It's just kind of like, it is what it is.
Can I ask you something about the refund policy?
Sure.
Do you have to give refunds, or can your refund policy be no refunds?
It can be no refunds. I mean, there are some places where there might be things on some high ticket purchases where you've got to give like like a lemon law type of thing, or a 48 hour, but generally you can have a no refund policy, especially if you're a service provider. So if you're a service provider, most everybody's going to say no refunds. But you just have to set it out. And so, for example, it may be that let's say you sell courses and some other stuff. It may be that your basic policy is no refunds, but then for this one course, you do allow refunds, and you can do that with a separate agreement. But no, you just set out what your policy is. If it's no refunds, you say no refunds. Or if it's, 30-day money back guarantee, you set that out. Whatever your
24, 48 hour.
Yeah, whatever you want. You set that out in there as your basic standard policy. So that all kind of goes into your terms of use. And so other things that you would put in there, if you have downloadable freebies on your site, you're generally going to say that you're allowed to use that for yourself and your own business. You're not allowed to make any other use. So in other words, people can't download it and then start making copies and giving it to other people and things like that you would put into your terms of use. Then the final document, and Nicole, you're really good. I think you're really great about this in your emails. You have all this. You have to have a disclaimer. I think you're the one who has a big old disclaimer in your emails. But on your website, you need a disclaimer. And there's a lot of different things you put in there. One, if you're a coach, if you're giving any kind of information, if you have a blog, you're going to say, I'm not giving you professional advice. This is educational and informational purposes only. So don't expect that it's anything like that. Then you're going to have things in there that is these results are not typical. You're going to go a little bit more depth than that, but you're basically going to say, look, to the extent that I report other people's results, that's accurate, it's truthful, but I'm making no guarantees. That's not typical. Your success is based on your own efforts and blah, 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 all those other things. Then, even though you're going to have to disclose this stuff elsewhere, if you're getting things like affiliate revenue, or you're getting products for free to review, you're going to go ahead and put that in your disclaimer. Again, you're still going to have to disclose that in the actual place where you're doing it, but you might as well put that in your disclaimer too. And then the final thing is you're going to say, again, big, ugly legalese paragraphs that say, I'm not liable to you for anything. And if I am liable, you can't sue me for this 18 different kinds of damages. And you're just going to put all this stuff that tries to limit your liability as much as possible. So again, big picture, 3 documents: privacy policy, which is about data. What do we do with it? Terms of use, basic rules of the road. And then your disclaimer is kind of a catch-all of saying, don't sue me, and meeting regulatory requirements.
Awesome. I have had so many websites, and I used to be all up to date on it, but right now everything's pretty much down because of my rebranding. So I think I'm just going to plug you right now that you do sell that stuff to entrepreneurs. And I think I'm going to have to grab your stuff that's more up to date. So we'll talk about that after.
Okay, great. Yeah, I mean, I sell that stuff, and especially that stuff, I sell it cheap. I don't think that stuff should be, expensive. Some people sell it for a lot, but that stuff, most of it is legalese, legalese, and it's just standard. But there's some stuff that, the forums I say will show you, and again, this comes back to, it'll show you the kinds of things you need to include based upon what kind of business you have. So you need to make sure you do that right.
Awesome. And you'll let us know how to get all of that support at the end. But now let's jump into how to protect your confidential information. Why is that important? And what do we do?
Okay. So again, like I said, some businesses and entrepreneurs immediately get this, right? I mean, if you're creating products and stuff like that, people will get that immediately. But a lot of entrepreneurs don't think about the fact that you have a lot of confidential information in your business. Let me just go down some list of things: your email list, your CRM database, if you have a special way of doing something, a special method of doing something in your business that's actually valuable and has something, all of that is valuable. Or let me give you another example that applies to your business, Nicole. You, in your business where you help match people to podcasts, I'm guessing you have a database of podcast hosts, how they like to be contacted, what kind of information they like. And if, for example, one of your workers were to take that database with them and go leave and start doing the exact same thing using that database, you wouldn't like that, right?
Well, they can't take anything and they can't do this kind of work for 2 years after they leave me, according to my contract.
Right. And what I'll tell you is you have a contract, and in some states that they can't do this kind of work would not be enforceable here in the United States. For
Is
example,
that right?
in California, you pretty much can't do that. There are certain states where you can't.
So people can steal your stuff
No.
become your competitor?
No. You can't tell them that they can't do the same kind of work. You can tell them they can't take any of the confidential information they learned from you and use it against you in the future. So that's where this becomes valuable. Rather than have a non-compete, you're often with workers, with contractors, going to want to have a confidentiality provision.
Oh, yeah. Okay.
That says essentially anything you learn here, you can't take with you. And the reason why I brought up the podcast matching, the first time I think we got connected, I was trying to decide who was going to work with me. I worked with a different company instead of you, and I'm sorry about that.
That's okay. I know.
But so I worked with this other company and I signed up with them, and they were using nothing but independent contractors initially to book people on shows. And so the person I dealt with day in and day out was an outside contractor. But the company decided to actually get rid of contractors and bring it in-house for employees, literally within, I think, a month and a half of me signing up with them.
It was quick.
Yeah. And so then that meant that this contractor that I'm dealing with was no longer going to be at that company. And if you just think about it, if she would have come to me, if they didn't have a right contract and she said, hey, Bobby, I know what you're looking for. I know who we pitched you to already. I think I can keep working for you. I mean, I probably would have said, well, sure, because you're the person I know. This woman, her husband, the one who runs the company, her husband's a lawyer. So she had these confidentiality clauses, which prevented the contractors from doing that.
Really?
Yes.
Because, okay, now we're getting into some dirty stuff then.
Uh-oh.
Because I know of at least 3 of those contractors that went and started competitive businesses.
Well, no,
their client load.
Oh, with their client. Well, see, and again, they shouldn't have, because again, the contractor I was working with started another business, but did not try to solicit me. And so again, those people may have violated the rules, but having that in at least gives you the protection. If you don't have a confidentiality clause with contractors, it's kind of a gray area. You might make an argument that, well, they should have known it was confidential, but it's not clear that they can't use it. And so you don't want to put yourself in those shoes. I mean, that's one of the examples, but there are a lot of other places where, let's say you wanted to investigate doing a joint venture with someone, you should have a confidentiality clause in place before you share any ideas with them. You just want to get in the practice. If you are going to share anything that's confidential to your business, don't do it until you have a confidentiality agreement in place. There's other basic stuff that's, you should have physical security and electronic security. I can't believe that there are still people who have their cell phones not protected with a password, which I'm like, if somebody got my cell phone and it wasn't protected, I mean, they could get all kinds of information. So,
or a fingerprint.
Well, yeah, right. Just have something so that someone can't just grab your phone or your computer and, start using it. And then physical security. I make the joke. A movie I love is called Spy Game. And it's Robert Redford. And there's this one time where he can kind of see something that someone hasn't covered right when they're in their office. Well, it's the same kind of thing. If someone's coming to your office, lock up your confidential information. Don't let them see it. So those are the basics of protecting your confidential information. But the big point is use confidentiality clauses and agreements in, contractor agreements, employment agreements, and then anything else you're doing where you're going to share the information.
Awesome. This is so useful and got my brain turning. So I'm going to have to go back and revisit my contracts. Um,
Well, yeah. So again, where you are, it may be that you can get away with those non-competes, but put a non-compete, but also put a confidentiality so that if the
I'm
non-compete
I'm
isn't
sure personally I have it.
yeah,
I have to, because they're long lawyer contracts. So
yep,
I just have to go back and double check. I'm pretty sure there's also something in there about if they do take a client, what that what the value of that is or something like that. Does
yeah,
that help or?
and so again, what I'll tell you is like all of those kinds of clauses, like different places they will be enforced, sometimes they won't be enforced, and so the one that normally will always be enforced is a confidentiality clause, which is just hey, you can't use this stuff, but you could definitely do that. And most places you could have, even if you can't have a non-compete, you could have a non-solicit, so they can't solicit your existing clients for some period of time.
Does it matter where, like, so for example, in my contracts, it states the jurisdiction. Does that matter where it's like put in there for that?
It should. So it should. It, so again,
There's too many
no,
specifics.
we're going to get in the weeds here. And so in the law, there's what's called choice of law. And it's kind of different. Again, I don't know the Canadian system other than knowing that Quebec is different and has a different system than everybody else.
Let's forget Quebec.
Okay.
Sorry, guys.
But so here in the States, for example, each of the 50 states has different sets of laws, plus the District of Columbia, plus our territories. And so if you sue this is where it gets really complicated. If I were to sue someone in Washington, D.C., there are what are called choice of law rules, where the court in D.C. is going to decide what state's law it will apply. And it normally is going to apply its own law unless there's a reason not to. And so that's why if you, for example, had something in your contract that said, number one, the cases will be filed only in the Washington, D.C., and Washington, D.C.'s laws will apply. It's very simple. The court's going to apply that. If you don't have that, it's going to apply all these weird different factors. So that's a long way of saying, yes, it probably does matter. And again, I always use California as an outlier because they are in a lot of these things. Like this is an area where California just does not honor non-competes. They believe people should be able to, do their profession and should not be limited. I think there's some wisdom to that, maybe potentially. I get it. And again, it's in different areas. Like I have a friend who's an expert witness who went to work for a company or almost did that wanted him to sign something that said he could not do that profession for 2 years if he left there. I said, wait, what? I mean, as a lawyer, we could never sign that agreement or never would sign that agreement. But at any rate, if you're in California and California law applies, you're not going to have a lot of that stuff apply. So you might want to say that it doesn't apply. So you can use those kinds of provisions in contract to avoid that.
Awesome.
Again, going back to get your agreements in writing.
Yes. Perfect. So let's jump into legal basic training on intellectual property issues.
Okay. So this is one where, again, like I said, when in the intro, a lot of people don't like to hear this, but you have to have a basic working knowledge of a lot of these concepts because I see people making mistakes all over the place and it gets them in hot water. Now, what I like to tell people is there's been studies done that say here, that they were in the United States, it said of a typical company, 75% of the value of a typical company is in their intellectual property. And intellectual property, it's a fancy word for anything that you could own that you can't hold in your hand and isn't a piece of dirt, basically. So it's kind of the intangible stuff. So things like copyrights, trademarks, your goodwill, all of that stuff. Well, what I like to tell people is if 75% of an average company's value is based on that, if you're in the online space, 95% or more of the values from that. I mean, I look at my business and I'm sitting here in my office. I've got some computers, I got some printers, and everything else is up here and those kinds of intangible assets. And so this is the most important piece of what you own. It's also where you're most likely to get yourself in trouble. So for example, the biggest mistake or most common mistake I see people making is using pictures or images without permission. And Nicole, I'm sure you've heard of the Getty image letter because you've never heard of that. Oh, I'm surprised.
I don't think so.
Well, you know who Getty Images is?
Yes.
That they're one of the big. Okay, so they aggressively defend their copyrights and images. So if you were to, let's say, be surfing around the internet, see an image you like, and do what I call the right-click save as problem. Ooh, I like that image. I'm going to right-click and save as, and I'll use it later. If you do that, they will find out. And Getty will send you a letter, and they will say, hey, thanks for using our image. We charge $3,000 for that. Please pay us $3,000 now. And the problem is you don't have much option because you use their image without permission, and that's a copyright infringement. Now, Getty is one of the most expensive, but there are a lot of the other ones. If you make this mistake and people find out, you're going to get a letter or an email or something, and they're going to demand somewhere between $750 and a few $1,000 normally. If it's one of the smaller ones, maybe you can negotiate them down to a few $100. But you come to me, I'm going to say, I don't know what you want me to help you with. I mean, you use their image without permission. Pay them and be done with it. And so that's kind of an example. And so with that, let me kind of walk through the different areas of intellectual property so you understand them at a high level. First is copyright. That's what we're talking about now. Copyright protects content. So it protects your blog posts. It protects everybody else's blog posts. It protects images, videos, music, anything like that is protected by copyright law. And the good thing here is that copyright law is almost universally the same in every country. Something like 180 some odd countries have signed on to what's called the Berne Convention. You don't need to know the name, but it basically says here are the rules. And the important part is you get protection automatically. You don't have to do anything. You produce something, it's protected. It's good for you, but it also means everybody else's work is automatically protected. So you can't use a video, you can't use an image, you can't, take a copy of someone's work. And here's something that people do that you're not going to get in trouble for, but technically if you screenshot somebody else's website and show it, you're not allowed to do that because they own that content, you don't. So the way to avoid problems there, you got to get a license or permission from the person who has the rights to it before you use this stuff. So we talked about images. Let me give you one other example of something that people do wrong here. They think that they can play their favorite music either on their podcast or live or something like that. No. You cannot do that. And some people think you can use up to 7 seconds and no, you can't use it, period. So don't do that. You've got to get music the right way. I don't know where you got yours or get yours for your podcast. I think mine came from Audio Jungle. You've got to go to one of those places and buy licensed music.
Yeah, I bought some pack of stuff.
Yeah.
I'm not even using it right now. But yeah.
And the other thing is so you got to just get licensed pictures, music, et cetera. And you can get free ones. Yes.
Actually, I've got a question for you. So one place I found, if you want to splice stuff together and kind of make your own, so tell me if this is okay. It's called hitrecord.org. And it's a collaborative where people put their stuff up for Creative Commons, I guess, where everybody can use it to create their own stuff.
And you can check that out as long as the license says you can do it. So if for any of this stuff, so for images, for music, for video, for any of that stuff, you're looking for 3 things in a license. You're looking for 1, that commercial use is allowed. 2, you want it to be what's called royalty free. That doesn't mean it's free. You may have to pay for it, but it means that it's not based on how much it's used, downloaded, listened to, etc. And then the last thing is you want something that does not require attribution. And that's the piece you have to be careful with some of the Creative Commons licenses. Some of them you don't have to attribute, but some of them you do. And again, there can be very valid reasons why you as a photographer, for example, would want attribution, but there are also what are called copyright trolls out there. They put their stuff out there and they say, you can use it for commercial use and it's royalty free, but you have to give us attribution. And they're doing that hoping that people don't realize, and then they're going to sue you for copyright infringement. And they're again going to ask you for a few $100 to a few $1,000 because you didn't say this is owned by so-and-so. So be careful about that piece. I don't know that particular site you're talking about, but if it is a true, I think it's a CCO0.
It's from Joseph Gordon-Levitt, and they create content from there. Question though, so sites like Pexels that have supposedly royalty-free content for you to use, how do we know that something actually is if we get it from one of the sites that says, or like even on Canva, like I have Canva for work. So there's a lot of graphics that are without cost that can be used. And also, you pay $1 to use it, stuff like that. So how do we protect ourselves in knowing what's real and what's actually like stolen?
Well, so what I would say is I use Pexels, I use Pixabay, I use Unsplash, and I don't think twice about it. I've reviewed their licenses. I actually have a freebie that I have that walks through these 3 elements, and I have like a dozen sites. Those 3 are 3 of the ones that are on there because they're the ones I use. I've never worried about that issue, just because I don't think there are people stealing images and uploading them to those sites. Maybe there are, but I don't know why you would do it. But you actually bring up an issue, and I'm going to go down this rabbit hole. I'm not sure that I should, but I'm going to. There was an interesting case that was just decided here in the United States, where the United States Postal Service got sued for copyright infringement and lost because they created a stamp that had the Statue of Liberty on it. And they got it from what I think they got it from, let's say, Pixel or one of those sites, not one of the free ones, but they bought it from one of those, and that was fine. So they had a right to use the image. The problem was it wasn't the actual Statue of Liberty. It was the Statue of Liberty from New York, and Las Vegas, which there's a copyright protection in that sculpture. And so the person who owned the copyright protection in the sculpture sued them and won money. So the point of that is if you have a picture that has art in it, or that has a sculpture, or that has a very famous building, there are protections in those separate. Again, don't have to worry about doing the New York skyline because that's broad. But like if you were doing a picture of a specific building, there might be an issue there. So you should think twice. Again, normally it's not going to come up. But those issues are out there. I don't use those kind of images personally. I don't use a lot of sculptures and art and things like that. So it's not something I worry about, but it is
great to know for the audience though, who does. So
it's a theoretical issue. You need to make sure that the person who took the picture has the rights on those kinds of things. And like I said, it's artwork and sculptures and buildings are going to be the big things where there's copyright protection in the underlying work that you have to think about. So, awesome. So that's copyright. Now let's go on to the next one, which is going to be quick. That's trademark. We already talked about this in creating your name. So you need to understand that, but it's not just names. It's also slogans, it's logos. I mentioned that I had to change what I was thinking for the names of my courses. So it applies to your course names and all of those things. And that's just a matter of searching, make sure nobody else is using it. The third area is trade secrets. This we already talked about too. This is confidential information. So use basic physical and electronic security, and then use confidentiality agreements, and you're good there. The final area is the right to publicity. This is the concept that allows a celebrity to sell their endorsement. So you think about that. You understand with celebrities. Well, the fun thing is you and I both have that protection too. And I love you and I are we're in the minority for our podcast where we actually make people click a little box saying that we're waiving the right to publicity. Most people don't do that, which I think is hilarious. And
wait a minute, waiving the right to publicity? I don't think I have that box.
Yeah, you do.
The media release?
Yeah, the media release. It includes that. Yeah, it includes it. Right. So no, you have that. And you don't have to use the words right to publicity. You're just saying that, you have the right to use it for anything and everything. And so the thing is, again, this is an area of the law that is governed by state law here in the US. It's very different from state to state. So there are some differences, like I think it's Indiana. One state protects my signature, even under the right to publicity. But the basic rule is that a person's name, image, and likeness are protected, and you can't use it commercially without permission. So that's the basic rule. But here's the sub rule. Some states you can have implied consent or oral consent. Some states technically require a written agreement to waive the right to publicity. So again, what I like to say is, let's use the podcast example. If you don't have a waiver when people sign up, chances are no one is ever, I mean, I'm coming on your show, obviously, because I want you to, use it. But here's where the thing comes up. What if in the future you want to make a freebie of the 100 best pieces of advice I've heard from entrepreneurs on my show? I didn't implicitly waive that and give you the right to use my name, image, and likeness for that. If you get a written waiver, it says that I can do anything and everything with it. So you have that protection. So that's one example. Other places where this comes into play, a testimonial. When someone does a testimonial for you, you need to get them to say something. Again, you can do this in email. I have my testimonial set up through SurveyMonkey. Somebody has to click a box saying I can use it for whatever I want. And so you got to do it there. But you should also think for guest blog posts, if you have a course and you're going to have someone as a guest teacher or something like that, you should always be thinking about those things. And it's other little things, like, for example, in my course agreement for online courses that I use personally, but also for my template, it has a clause that says, hey, by participating, if you participate in a Q&A, I have the right to use that, because you just want to protect yourself so there's no question on it later. Now, other businesses, it's going to be more the endorsement and implied endorsements you got to be careful about. But really, it's just think about if you're using someone's name or a picture or anything like that of them to try to promote your business in any way, you need to get permission. And that's the right to publicity in a nutshell.
Thank you for going through that. I was just speaking with a very popular, well-known, and experienced podcaster the other day who's over 200 episodes in. And we were talking about, our forms and stuff. And she's like, oh, I mean, most people don't. You're right. Most people don't have that. And I was like, sister, you need to I was like, here's mine. I sent it over to her. I was like, you need to put that on your whatever it is people are signing. So,
well, and there's a separate issue that this is not the right to publicity, but, and again, this is kind of in the weeds, but like copyright law, it's an open question. Like, if you didn't make me sign something, who owns this? Do I own it or do you own it? But again, the way you have it written, I'm pretty sure in the way I've written mine is that I own it. If you come on my show, you're transferring copyright interest to me. And I think I did the same thing when I did your show.
Yeah.
So it's just, this comes back to let's avoid gray areas. Let's get written agreements in place to avoid disputes in the first place.
Awesome. And I'm going to, we are coming up to the end. We have 8 minutes left. So I don't know if that's a hard stop for you, if you can go over a couple minutes.
I can go over a few minutes. Yeah.
Okay. So I'm going to ask a question. This is very meta, I guess, because people are hearing this on my podcast, The Nicole Holland Show, or they're seeing it on the blog. But we're recording it before that show exists. Yep. And one of the things that I'm going to say now, I'm planning, and who knows what's actually going to be after you answer my question. So Thursdays, it's my intention to have many of those episodes, if not all of those episodes, be pieces of interviews that I did on other people's shows that are 9 to 13 minute clips where we introduce the show and what specifically we're talking about, so that, again, it's getting me out in front rather than me just behind and doing the interviews. So what I have done so far has been to contact the hosts over email to say, hey, is this okay? And they're all like, yes, of course. But is that enough, like getting their consent that way? Or do I need to have them fill out a form explicitly stating that I can use their interview with me?
So you need a written agreement, or you need some kind of written consent. And again, this is where, like, if you were asking me as my stickler, lawyer, legal, what would I tell you? I'd rather have a written form. If you were asking me as an online entrepreneur, if I were going to do if I were in your shoes, I'd probably just send the email and I'd rely upon the email. Honestly, that's what I would do, because what's the chance that someone who said that and put it in writing said I can use it is then later going to complain about it?
And they're people that have already hosted me, and I'm sending people back to them. But I think, you know what? Who knows? Who knows what's going to happen? I might just make a little form for them to approve once I cover the
Yeah.
content. So,
And like I said, this is where I have to wear two hats. I haven't thought about the question closely enough to say, do I legally need the form? I would feel more comfortable if I had a form, et cetera. But realistically, I probably wouldn't do it. I would probably just go with the emails just because, at some point, my business hat overtakes my legal hat, realistically, even in my own business.
copy. Cool. So is there anything else that we didn't cover so far you wanted to cover in this masterclass session?
I think we covered the big things. What I would say is that there are also other concerns that come up based upon what you do. So, one example of that are coaches. Depending on what kind of coaching you're doing, you may have issues that you have to think about. Well, do I need to be licensed in another state? And do I have to be careful of those things? You just need to be aware of those things. It's not a huge deal if you're doing things like life coaching or something like that. But if you're in the health and fitness or nutrition or something like that, or if you're counseling, obviously there are obviously rules. Lawyers, if you're actually providing legal services, there are rules. So you have to be aware of those things in today's day and age, but most people should know those kinds of issues. There's also in the online space over the next couple of years, and I can't really give any good guidance on this, there's going to be some changes when it comes to sales tax. The law here in the United States until earlier this year was that unless you had a physical presence in a state, you did not have to collect sales tax there. That was just a rule. That was a rule of constitutional law. Our Supreme Court changed that this year. And so over, I think, the next 12 to 18 months, we're going to have some states passing laws that are going to change that and are going to require people to collect sales tax. So for your e-commerce people, I assume they're going to be aware of this. They need to be aware of it. In the coaching and course space, it's different because often we're not taxed anyway, even if we have a presence in a state because of the kind of service we provide. But you do need to make sure that you're keeping up with the sales tax rules and the sales tax laws that are going to develop over the next 12 to 18 months. But I can't really give any guidance because it's coming. So be on the lookout for it is what I would say there.
So helpful. And as always, you're so helpful. And of course, like I mentioned earlier, your Online Genius is your podcast where you give lots and lots more. You've got a Facebook group, you've got programs, and I think you've got a checklist for our audience if they want to kind of get into your world and get more of your genius to help them with their online businesses.
Since you said it like that, though, I've got to say something. Let me ask you a question, Nicole. When you hear your Online Genius, what do you think that means?
I just think of you. I mean, it's just, your branding is good.
Well, so that's the thing. I realized literally within the last month and a half that's what people thought. I'm not the genius. I'm here to help you protect your online genius. That's the meta behind my brand, although I realize that people aren't getting that. And I think now it's become an inside joke with folks that I'm calling myself a genius. But
you know what? I mean, own that because I mean, for me, I know the Big Leap had a big impact on me when I read that a couple of years ago. And because before I was like, my genius, my own genius, whatever. I knew what it was, but I didn't want to talk about it. But now I'm like, oh yeah, I know where my genius is. You want to talk strategy? You want to get your systems done? You want to get yourself out there? I'm your girl.
Yeah,
so own it.
No, and I own it because it's a joke because, there's a lot of things in my life. Earlier in my life, especially, I was known for being a bit, shall we say, self-assured. And so people made fun of me.
Arrogant?
So people made fun of me for these things. And so it was kind of a running joke that kind of fit. And I had never even thought that that's what people would think of it. Man, I came up with the branding when I was launching my first course, which flopped, called Safeguard Your Online Genius. Mm-hmm. So the course made it clear that I was talking about yours, but I don't mind owning it now. And I think it's a good joke.
So good. It's not a joke. You are a genius. And you know what I love is that you are so good at breaking things down that most people get overwhelmed by, and most people who know, most attorneys treat people who don't know like they're idiots. But you don't do that. You break things down into real talk, real speak, and you don't treat people as though just because they don't know what you do, what you know, they're less than. And I find that it's unfortunately very common. And it's what you do is so brilliant and so generous and so wonderful that it is wonderful to be able to tap into your offline genius, into what you're an expert at, in a way that we don't feel like we are less than or incompetent.
Well, and I appreciate that. And please don't get me started on other lawyers. I've long said that the worst part of my job as a lawyer is that I have to deal with other lawyers all the time. And, you know, I think most lawyers they're not doing it on purpose. They just don't know any better. I mean, I'll be honest with you. Most of my law school professors were horrible teachers because that's not what they do. And, you know, I appreciate the compliment. One of my favorite lines to say is that law isn't rocket science. There's a lot of stuff you need to know, but it's actually not that complicated. There are some things that are, but most of it is just lawyers use a lot of words that they try to make things complicated. And you know, I hate it as much as you do, I think. So I appreciate that. So I definitely appreciate that. I think you were asking where people can get me. I've got the checklist. Yeah. They can go to youronlinegenius.com/checklist. I call it my ultimate legal checklist. It goes through basically kind of what we went through today. So you can have it in writing and have that as well. That'll get you in my world. Once you're in my world, I also, as we're recording this, it's not quite live, but by the time it goes live, I have a free membership site that has somewhere between 25 and 30 training videos that you can watch. You can get it absolutely free. If you get on my list, you'll find out about that. And you know, I go deeper on these things. So if you want to really learn this stuff, you'll be able to. So, you know, my goal is to educate people and empower entrepreneurs. I like to say what I want to do is I help you take care of the legal stuff so you can get back to doing what you should do, which is building your amazing business. And I like playing some small part in helping people build their businesses.
I love it. And then, of course, once you're in there, you can connect with Bobby on whatever you want. But if you're like me and you're like, okay, I know I need this now, I'm going to have some links as well on the show notes page that are more up to date, because we are recording this in mid-September. And I don't actually have a relaunch date yet. I was going to go for November 1st, like the last 3 years of the summit have started. But I checked my bandwidth and decided I think I need to just put a question mark on it right now, so that when you're hearing this, everything is smooth sailing and going off without a hitch. And you're going to get so much value, I hope, from the Nicole Holland Show and from all of our guests and master classes and all of the things. So definitely check out the website. And there will be more amazing content there that drives you to Bobby and his world. And also youronlinegenius.com/checklist to grab that up.
Yep. That'll be perfect. And I'll give you all the links so that if you want it, and you just let me know when it's going to go live, and I'll give you up to date on anything, so people will have access to anything and everything that'll be helpful.
You bet. Thank you so much for being here today.
Thanks. It's been a pleasure.